if they are silencing us from being corrected, that you're deviating from the constitution values, it doesn't mean they're foolish. They don't know better. It means they do not want the constitution to survive. They do not want this republic to survive. That's why they're silencing voices that question whether they are actually taking forward the constitution mission or not, because they don't want anyone to think about it. I just appeared in the Supreme Court 2-3 days ago in a case representing a scheduled caste litigant, and the other side is not filing its counter, and we were about to get a favorable judgment, but for 2 months after the court deadline, the counter is not filed. They're not even properly appearing. So I said to the judges, I said, you know why this is happening? Because this litigant is a scheduled caste woman. They have contempt for her. They think she's worth nothing. Otherwise, as important people, you'd have had all the lawyers and everyone there. And so we are now in a situation where but at the same time we are told there is no caste system. Where is caste? There is no caste in this country. But the fight is over caste, and that's another long discussion. So we must understand that this conflict is taking place. This same conflict took place in Kochi, and there we did not get this kind of reaction from Kerala's civil society, I'm very sorry to say and ashamed to say, where an activist, not a lawyer, an activist, was actually sent to jail for contempt because he said the same thing about 2 judges, pretty much, that they're talked about their relationship with the same retained Savarna supremacy group. So this is a no-go area. Now, why is this a no-go area? Because we have to understand that caste, there's a conflict between the caste and the constitution. So these 4 or 5 political forces emerged from the Constituent Assembly. And our constitution, I believe, is very unique in the world. Because normally a constitution is simply a document that sets out certain rules, fundamental rules, and so on and so forth. But our constitution, given this conflict in the Constituent Assembly, and this is the genius of Dr. Ambedkar, is a site of struggle. And I thought I could do something. In the beginning, we could have a few questions, and I will answer those questions, and then we will proceed from there. Because if I give another exposition, I think it would be difficult to digest continuous speaking, and so I think if you don't mind, if you agree.
The audience is used to it. This is the 22nd session that we are having.
Right. No, but the audience is certainly used to it, but still there is some, we need a rest. So let's hear some other. So I'll say everything I want to say, but I'll frame it around in an interactive way. Because you've heard a lot about the issue. We are here to discuss the we all feel scandalized. Mr. Marutayan has described what has happened, and the meaning of scandalize is something that happens which shocks us, which we feel is against morality. So rather than the court being scandalized, we are scandalized, the public of this country, shocked by what has happened. And so let's see, if you have any questions that you want to talk about, you want to ask about, I'll structure my talk around that. So we'll have some...
Sir, this is about the contempt of court.
Yes, sir.
A friend of mine is also legally knowledgeable. He says that an aggrieved judge has the right to summon a person who has caused that grief to seek an explanation. And that is well within the boundaries of law. Please comment on that.
Yes, sir. First of all, I want to say that we are all gathered here not to talk about a particular judge, because Mr. What's the judge's name? Mr. Swaminathan, yes. Mr. Swaminathan was not a lawyer. He was a young man, student. Then he became a lawyer. Then he's become a judge. Now he'll become a former judge. Then, he will change. His role will change. He's temporarily in a role of a judge. We're not here to, I don't think we are here to discuss him. His actions are in a context. In my view, we are actually, the challenge is for us to understand what we are fighting against. We are not fighting against an individual judge or lawyer or anyone. We are fighting against something extremely important. The United States had its civil war in the 8th decade of its constitution. We are in the 8th decade of our constitution, exactly where the United States was when it had its civil war. We are in the middle of big civil conflict, which they called it a civil war, or big civil conflict. And I think we should understand what is this conflict between a lawyer who has incredible record of fighting for the people and democratic rights of people, and a judge sitting in a court. Is it simply a battle between two people, or is it something much deeper than that? And if so, we need to understand that. So I just want to say in context that we are here to understand what this battle is and what each of us should do to respond to that battle. It's a very critical battle that we're fighting. So in that context, sir, to answer your question, I was just, as I said, the essence of the Contempt of Court Act, which is colonial in nature. It's very interesting that the present government says they've decolonized the criminal law, but still the law against contempt has not been decolonized. Most democratic countries do not have such a comparable law as we have. It has three elements. One, the power. First of all, it's contempt of court, not contempt of a judge. What is a court? I theorize a court as an activity, not as a place, not as a set of people, but an activity that is conducted in accordance with some rules, in order to achieve one single purpose. That purpose we can derive from a definition of fact and issue. Many of us are lawyers here, in the Evidence Act. It is to determine the existence, non-existence, nature or extent of right, liability or disability. And if there is a right, to enforce it. If there is a disability or liability, to enforce it. Not directly, but to have the responsible people take necessary action to realize those rights or ensure that those liabilities and disabilities are met. This is why a court exists. And the court is concerned only with one issue: is human conduct right or wrong? The court doesn't go beyond the rightness or wrongness of human conduct. So court is an institution in which a judge has an important role to play, but the rules give mandatory roles for a number of people. It's initiated by a plaintiff or a complainant or a petitioner. There needs to be another party, there needs to be witnesses, there are officials. So all these people together constitute an activity. Now what the Contempt of Court Act says is that if there are three elements to this. One is, I'll start from the broadest one, which is if someone acts in a manner that the administration of this activity, which is very important to society, to determine whether the existence, non-existence, nature or extent of right, liability or disability. If there's a dispute over that, do I have a liability? Do I have a disability? Do I have a right? A right is a claim or a privilege. And liability and disability are the reverse. When two people disagree or more people disagree, we go to a court. And when the court decides that, we can then act peacefully without killing each other or attacking each other over that dispute. That's the purpose of a court. So when a court acts in this manner, the first a type of contempt is where someone interferes with the system itself. Someone somehow interrupts or obstructs the system from functioning in some way or another. So that is, contempt means, literally means thinking something has no worth, is worthless. That's the literal meaning of contempt. So when someone does not give any value, does not give any worth to having such a system, and acts and obstructs it without having due regard to the value of that system, we say That's contempt of court. That's at the largest level. Second is where someone obstructs a particular proceeding, not proceedings, one particular case or proceeding, not the whole system, then that also becomes a contempt of court under the law. The third is what concerns us. The third is where the court is scandalized. Right? Now, what does it mean to be scandalized? As I said, scandalized is, I am scandalized if someone behaves in a way, or let's say you will be scandalized if I behave in a way that is really shocking to you in terms of moral standards that you expect. Moral standards means standards of right conduct that you expect from me. If I behave in a way that is really shocking to you, then I've scandalized you. So when someone, the court, not the judge, the court is the totality of this activity and the rules that govern that activity. So when something happens that is not simply obstructing the whole system, not obstructing a proceeding, but something that is so shocking and wrong in terms of this entire system saying this is wrong, you should not do it, right? Because it has the impact of eroding the trust and confidence and the respect with which the system is maintained. It's only when that happens that a court should act, actually. And here the law is being administered in our country in an extremely broad manner that gives vast discretion to a judge, where you criticize a judge. So we've seen an instance where one person, Prashant Bhushan, tweets about a Chief Justice of India, and we are supposed to have slow justice, but within about 2 weeks of that tweet, he is convicted and punished by the highest court in the country. Because somehow this is supposed to have lowered the respect and dignity and trust and confidence in which people have held courts, have held the judicial system. So these are the standards that they should meet, before they issue summons. And we are talking about scandalization. It's a very high standard. It has to be utterly shocking to the system, to the whole system, not to the judge. So usually in other countries, if you attack a judge personally, not for his work. So there was a person who called the members of the House of Lords old fools. They're old. 3 judges of the House of Lords were called 3 old fools. And when they were asked to exercise contempt, they said, old is a fact. We are old. Fool is an opinion. They are entitled to that opinion. So they refused to take any contempt action because they didn't think that one person saying we are 3 old fools will reduce the image of the judicial system in the eyes of the country. I mean, who is this person does this person command such credibility that the entire country's opinion about the judicial system will say, because he said some 3 old fools have, it was printed in a newspaper with the picture of the judges upside down, 3 old fools, right, have made this foolish decision. These are all matters of opinion. And so the judicials, to some extent, I think and I will on this, read you there was a very wonderful judgment on contempt, which is a dissent written by Justice K.K. Matthew, who later on became a judge of the Supreme Court and became one of the most respected judges of the Supreme Court, and retired, and he is no more now. He was initially a judge of the Kerala High Court, and when he was a judge of the Kerala High Court, the then Chief Minister of Kerala, E.M.S. Namboodiripad, was hauled up for contempt by the Kerala High Court because he basically expressed a Marxist view that the judicial system is simply a system that favors the rich and the exploited. Very correct, respectful expression, with no personal malice, no judge singled out, saying, this is my view. I see this is as a very oppressive system of in this country. So they hauled him up for contempt, and Justice K.K. Matthew wrote a dissent, and in that dissent, which I will read to you shortly. This is it. See, what Justice Matthew writes is, the interest of society in self-government by free discussion. The interest of society in self-government by free discussion is much more important than the maintenance by coercive processes. The maintenance by coercive processes of artificial and hypocritical respect for courts and judges. Immanuel Kant said, says Justice Matthew, in his Metaphysics of Morals, that love as an internal feeling cannot be commanded. So also respect cannot be commanded. So Justice Matthew writes in this dissent that he focuses on the value of free discussion in a society. And he says contempt of court, which is a negative comment about a court, and if it's about the judge, it is equivalent to defamation, which is defamation is lowering, defaming, taking away the fame. It is lowering the respect with which anyone is held in society. It's equivalent to that at a personal level. Even, are you defaming the judge? And in many other countries, if you defame a judge, he can bring a suit against you like any other citizen in a normal court. But he cannot use his judicial power against you. But Justice Matthew says that whether it's defamation or contempt of court, which are some of the grounds on which under Article 19(2, freedom of speech can be restricted. He said these are all types of speech which have no positive content in society. For example, if you say judges are 3 old fools, it doesn't contribute to better understanding of anything. It's just a sort of angry response to a court. So he says if there is a positive contribution in a speech which is critical, for example, someone says hypothetically that please watch out that this judge is doing his work in tandem with the RSS. It's a very serious comment. If it's said without any basis, certainly we can say this is without any basis. But if he has a reasonable basis to say that, that is something that we need to take, the public needs to know and take into account and look into. It's not like saying he's an old fool. It has no value. So Justice Matthew argues that only that kind of speech can be restrained, which is basically wasted speech. There's no value at all. Not because it's critical, but because it has no value. But where speech has value, it's an opinion, it's a considered opinion. If you restrain that, then that society is going to suffer. Because as he beautifully says, if you want self-government based on free discussion, that's the assumption of the Constitution, self-government by free discussion, then whether it is positive or negative, any kind of serious comment, critical or not, should not be restrained. Justice Oliver Wendell Holmes in the United States had a big conversion from being anti-free speech to pro-free speech. After a series of conversations with some academics and some fellow judges, on one basis, and he said, those of us who are holding power in society, we need to know whether our decisions which affect our country are right or wrong. we assume they are right, they're well intended. But the only way we can know whether we are right or wrong and we miss something is if we let those who disagree with us speak freely. There's no other way for us to know whether we are right or wrong. So critical free speech of a serious nature, a serious concern, becomes very essential for the well-being of a society, is essential for the well-being of a society. This is the main point that Justice Matthew makes in his dissent. Here is a Marxist point of view. Justice Matthew was not a Marxist. But here is a Marxist understanding of the judicial system. It's a serious understanding. It's a different matter that the Kerala High Court convicted him with Justice Matthew dissenting, convicted the Chief Minister. It went to the Supreme Court where the conviction was upheld. And one of the judges then lectured EMS on what Marx really said. You don't know what Marx said, this is what Marx said. So someone was telling me when we were discussing earlier, it is like if if a judge of the Supreme Court from some other state lectures, let's say Annadurai or Karunanidhi on Periarism, right? You don't know what it is, this is what it is, right? And but so they were correcting him rather than considering. You can consider and reject, you're in power, you're not obliged to accept what people say, but you must consider every point of view. So what we understand from this, I'm sort of enlarging your question, sir. What we understand from this is that there's something going on here. They're doing this because, see, Oliver Wendell Holmes said the way I can protect the United States' interest as a judge of the Supreme Court of the United States is to hear my harshest critics speak when I judge against me, personal or not, as long as it's substantive. I have to hear, because then I'll know if I made a mistake, somebody will tell me this is wrong, and then I can correct myself, then the country won't go wrong. What was his objective? His objective was to protect his country and take it forward. If somebody is not doing that, that means they're not protecting the country. It's not that they don't know this. If they are silencing us from being corrected, that you're deviating from the constitution values, it doesn't mean they're foolish, they don't know better. It means they do not want the constitution to survive. They do not want this republic to survive. That's why they're silencing voices that question whether they are actually taking forward the constitutional mission or not, because they don't want anyone to think about it. Now that takes us to the question, why are they doing it? And in a very short and simple way, I said that we are in the middle of a civil conflict. What is that civil conflict? We can see the civil conflict in the Constituent Assembly. We can see it starting in the 19th century. The 19th century in India was a century devoted to the fight against caste. Anti-caste movements came up all across the country. I've studied this more intensely in Kerala. In Kerala, no less than 15 giants emerged in Kerala to fight the caste system. Narayana Guru and many others, I won't give you the names. Vakam, Maulavi, so many people came up, all saying with unison, this caste system has to go. The last person born in that century was actually Dr. Ambedkar. Not in Kerala, but at the national level, but had a big impact in Kerala and all across the country. And by the middle of the 20th century, when India became independent, they had really brought this anti-caste movement into a crescendo, culminating in the historical call on behalf of the entire 19th century of Dr. Ambedkar annihilate caste. And he gave us a very specific way in which to annihilate caste. Dr. Ambedkar, in the middle of this in 1930, warned that when the British leave, India will be ruled by a caste oligarchy. And he said representative democracy is the only way to stop this caste oligarchy. And today, India is ruled by 4 communities. Almost all power. And that's across the ideological spectrum. Across all spectrums. But if you go to powerful positions, media, academia, government, economy, everywhere, the overwhelming domination is by 4 communities. And so India is an oligarchy. Exactly as Ambedkar had predicted. And this oligarchy, once it took power, completely suppressed the anti-caste movement. So in the 20th century, suddenly this anti-caste movement came to a grinding halt. And today, there is no space to talk about the anti-caste movement in this country because the oligarchy will silence you. What happened in this case is an anti-caste voice is being silenced. Wherever an anti-caste voice comes, that voice will be silenced. In fact, I would argue that it is the anti-caste movement that was presented as the national freedom movement. Because for a century, the people had been mobilized against caste. But then it was captured and taken to a different direction to protect and defend and maintain the caste oligarchy. And the constitution which emerged from this anti-caste movement was created in a constituent assembly which had, I would say, 5 forces battling inside it. That's the battle that's going on. 2 forces on the left, 2 forces on the right, and 1 at the center. Let's say on the left, there is a social left and an economic left. The social left is a group of left, which is a word that came into the vocabulary about 30 years before Marx was born. It simply means on the side of the people. Consists of those who believe that the social order has to be totally changed before India can move forward. Social order is the base. The economic left, but they agree that economic production relations must be democratized and political systems must be democratized, but they believe that the social order, democratization of the social order is the first priority. The economic left consists of people who believe that the production relationships must be first prioritized, and so social order is part of the superstructure, and it will automatically change. The social right is the RSS. RSS stands for Retain Savarna Supremacy. That's what I mean when I say RSS, right? Retain Savarna Supremacy. And the economic right consists of the neoliberal, capitalist, free market people. And the center consists of a very uncertain group of people who believe that India can be transformed through techno-managerial policies. Improve efficiency of governance and change this corporation and privatize that and put more investment here. And that's basically the space that the British tried to occupy also, this techno-managerial approach to improving human conditions without bothering about the fundamentals. Now, 75 years later, the semi-finals are over. The finals are between the social left and the social right. The economic left outside Kerala has been completely marginalized. Even in Kerala, Mr. V.S. Achyutanandan, who we just lost at age 101, the biggest mass leader that the Marxists have ever had, or anyone has ever had in Kerala, tens of thousands of people streamed out onto the streets to mourn him after he's not been active for over nearly a decade. crying and full of extreme sorrow to have lost him. He said in 2013 that the left movement in Kerala is nothing but a supporting structure to strengthen the Srinarayana movement. He said, that's how we have the Communist Party in 57. Our Communist parties, our labor movement, our agricultural workers movements are all efforts to strengthen the Srinarayana movement. So we can see why the economic left may have actually been the social left in Kerala, according to Achyutanandan, who came from, he was born as children of landless, ordinary workers. And he lost his mother at 3, his father at 11. He was orphaned and in utter poverty. And from there he emerged into one of the great leaders that Kerala has had. So social left and social right are fighting. Over what? Over the caste system. So if Mr. Vanchinathan had challenged anything else, he may not have had this consequence. If he had, I just appeared in the Supreme Court 2-3 days ago in a case representing a scheduled caste litigant, and the other side is not filing its counter, and we were about to get a favorable judgment, but for 2 months after the court deadline, the counter is not filed, they're not even properly appearing. So I said to the judges, I said, you know why this is happening? Because this litigant is a scheduled caste woman. They have contempt for her. They think she's worth nothing. Otherwise, as important people, you'd have had all the lawyers and everyone there. And so we are now in a situation where but at the same time we are told there is no caste system. Where is caste? There is no caste in this country. But the fight is over caste, and that's another long discussion. So we must understand that this conflict is taking place. This same conflict took place in Kochi, and there we did not get this kind of reaction from Kerala's civil society, I'm very sorry to say and ashamed to say, where an activist, not a lawyer, an activist, was actually sent to jail for contempt because he said the same thing about 2 judges, pretty much, that they're talked about their relationship with the same retained Savarna supremacy group. So this is a no-go area. Now, why is this a no-go area? Because we have to understand that caste, there's a conflict between the caste and the constitution. So these 4 or 5 political forces emerged from the Constituent Assembly. And our constitution, I believe, is very unique in the world. Because normally a constitution is simply a document that sets out certain rules, fundamental rules, and so on and so forth. But our constitution, given this conflict in the Constituent Assembly, and this is the genius of Dr. Ambedkar, is a site of struggle. For creating a new social order. And so it is quite expected that this kind of struggle will take place in the courts, where people in the courts will confront judges who are against the constitutional transformation, if any, and confront them. And they will hit back because there is a struggle that's going on. And so our constitution is a site of struggle. And in this struggle, we have to understand how the constitution is a weapon of caste destruction. Like they talked about weapon of mass destruction, constitution. Dr. Ambedkar has, although it's a site of struggle and it has provisions that benefit a lot of people, but Dr. Ambedkar has seeded in it lethal weapons against the caste system. Why? Because the caste system basically, from a legal point of view, my difficulty has been caste has not been properly defined. Caste has been defined by sociologists, Dumont and others in a particular way, by economists from the left who would see it as a group of occupation and vocation and exploitation of the working class, different ways of defining and understanding caste, all of which are valid from their point of view. But for me as a student of law, I define caste system differently. I define caste system as a system through which civil, political and economic rights are vested and taken away from social groups. By categorizing them into 1, 2, 3, 4 and 5 categories. If a social group is categorized into 1, you have all the civil, political and economic rights. If you're in 2, you have not all but a lot. 3, a little bit less. 4, a little bit less. If you're categorized into 5, which is where the vast majority of the social groups in this country are categorized, you have absolutely no rights. And you also don't have individual rights. This is the caste system. A system, very simple system, through which what you do is you tell people you have no individual rights. You will belong to the group into which you are born and you cannot change that social group. And it is comparable to gender, for example. You're born as a woman. You can change gender, but pretty much, until recently that wasn't possible to the extent it is now possible. But generally speaking, you stay with the gender into which you're born. And then you create rights and privileges around the two genders, male and female. And you're trapped in that. Similarly, we are all born into a family. Family is part of a social group. That social group is categorized into 1, 2, 3, 4 or 5. And that determines our life on what rights and privileges we have. This is the caste system. Justified in the basis of religion and Vedas and all that, but I disregard all that. It's completely just justification. After all, which system of oppressive government is not justified on the basis of religion? They all are. But basically the caste system is a system of government. It's a system of government through destroying individual rights, making sure that you have the social identity into which you're born and making sure that identity cannot be changed, and then categorizing your social group into 4 categories and controlling the civil, political, economic rights you have and suppressing them. It's a way of government. Now, which way of government is totally opposed to that? It's democracy, where everyone has individual rights, you have freedom of association, you have no rights, there's no categorization, and you have no rights attached to your social group. We all have equal rights, all social groups have equal rights. So by putting in individual rights, putting in equal rights for social groups, abolishing these categories and the privileges attached to them, Dr. Ambedkar destroys the legal basis for the caste system in this country. So no one can walk in here and say, I'm category 1, all of you get out. He destroys the framework. And therefore, the caste system, which is a system of government based on categorization, unequal stratified categorization of groups, giving and taking away rights, is totally incompatible and is fatally hit by the democratic, socialist, secular constitution that we have. And therefore, for those who believe in retaining Savarna supremacy, the constitution has to be destroyed. It's very dangerous, very lethal for them. And so I've been speaking for the last several months, saying I believe the Hindu Rashtra, it's very interesting. See, they say Hindu is a culture, it's a political entity, it's a way of life. In which case, in the coming census, why don't we remove Hindu as a religion from the census? In the census, it says religions, and our religion is marked as Hindu. But if it's a way of life, if it's a culture, then it should not be See, we can't say people who love Carnatic music are a religion, right? When we may say that popularly, but in the census, it doesn't recognize that. It's a culture, way of life. So I think we should demand that Hindu should be removed from the coming census as a religion, because it's not a religion, they claim. Actually, they're right. It's a political system. Whether the brand name, you use the brand name of Brahmanism, Sanatana Dharma, or Hindu, basically you're talking about a political system of government. And the census is only to pretend that there is support for this political system of government. There is a constituency for this political system of government. And so it is quite understandable that there is a mortal combat between the caste system and this our system of government. And so what should we do under these circumstances? The Constitution gives us the freedom of speech, and I really want to say that what we have to focus on is not just contempt of, we can't look at it in isolation as the power of contempt. We have to also look at what is the scope of our freedom of speech under 19(1)(a). And we have to demand that our freedom of speech should not be constrained. There are so many constraints being imposed on our freedom of speech. It's being virtually eroded and taken away. So I've been saying for some time now that this concept of Hindu Rashtra, which is the system of government called caste, that's what Hindu Rashtra is being imposed on us, not by a new parliament being convened. That may come after the 2026 reorganization of parliament, but not until then. And even then, it may be difficult by replacing our constitution with a constitution that reflects the Hindu political system. But by interpretation of this constitution through the judiciary as being a Hindu document, through what I'm calling theocratic judging, where the judges get the highest principles of law, not from the constitution, but from the Shastras and the Vedas, which they believe in. We are seeing that in many judgments, quoting Vedas and quoting the values of Shastras, and also telling us that Varna is a good system. The Supreme Court recently wrote a judgment in Devinder Singh, which is the judgment in which the scheduled caste subclassification was approved, saying that Varna is a system that brings out the best in people, and it's not caste. A number of judgments which have, also the Sanatana Dharma judgment of the High Court here. So there are many judgments which are actually telling us that the system of government, that is the enemy and opponent of our democratic constitution, is a good system. So what we must realize is that when people who are holding official office, whoever it may be, under the government, executive, legislative, judiciary, or teachers or lawyers who have an official role, when we associate with a system that is seeking to replace the constitution with another political system, another state, like a Hindu Rashtra, that is treason. That is treason. That is contempt of the Constitution. Not just contempt of the Constitution, it's a direct attack on the Constitution. It's treason. Because you're seeking to overthrow the Constitution. You're associating with people whose stated objective is to establish a different kind of Rashtra, which they cannot do without overthrowing this Constitution. And if that Constitution comes into place, what Narayana Guru said about it is, "Poyadallam thirichu varum." I don't know if you understand. All that is gone will come back. He said it in his usual, very succinct way. By the way, on the 11th day after the RSS, the Nagpurwala version, was inaugurated, on the 11th day, October 8, 1925, Narayana Guru issued a public statement in the press saying, "Hindu ennoru madame illallo." There is no such religion as Hinduism. It's not a religion at all. And then he explained that. I'm not getting into that. There's no time. So I think we can't look at it, sir, to answer your question, in a normal legislative power, administrative law manner. Where is your power? What are you doing? This is war. This is war. They want to destroy this constitution. I'm not talking a judge A, B, or C, but there is a force that is dominant in this country that, and they've written about it. Golwalkar and others have written about it. They are openly talking about it. This constitution. Many people in that group are saying we have to get rid of this constitution. It's copied from else. It's not copied from anywhere. If I have more, in another day, if I have more time, I'll explain to you its origins. Its origins is from the anti-caste movement. But they're misportraying it and saying we need to get rid of this and we need to find a new constitution. So they're very plain about it. Now, if you associate with people or movements that say that the constitution must be overthrown, to me, that is treason. And we should necessarily understand this larger context and not treat it in this in any sort of minimize it as a question of interpretation and so on and so forth, or treat it as an individual expression of one person sort of getting it wrong or something. It's like mistaking one soldier, if our country is attacked, for the entire force that is behind that attack. May or may not be. But we have to be worried about the real force that is behind the attack on our country. What is taking place is an attack on our country.
So you are saying this is a symptom of a larger malign.
This is a shot being fired as part of a large war against our constitution and our polity and our democracy and all these principles of equality and representative government that are in our constitution. Because they do not want the old social order to change. They want to maintain the oligarchy. Caste is an oligarchy which has a monopoly. And that oligarchy is not prepared to let go of its monopoly. And the constitution will dismantle that monopoly. So, okay, how do we have no time, but I'm sorry, I think we are running badly out of time. We feel that, how we should go forward is, first of all, recognize that this is part of a very, very serious battle that we are in. And how we can best respond to that is to double down on defending the Constitution, defending those values, but I think take care, as I think Mr. Vanchinathan has done, in the saying it in a careful way, in the correct way, so that the public understand what the real issues, what we are fighting. We are not fighting people. We are fighting to maintain our constitution. We are fighting against the retention of the Savarna supremacy and the caste system, a fascist and authoritarian form of government. And once we become aware of that, then people will realize what's going on. Even people inside the judiciary will realize what's going on. The lawyers will understand what's going on, and we'll be able to protect our republic. So I see our need to engage with this issue as very important for the survival of the republic. We are not just fighting for one person against another person. We are fighting for our republic against a very dangerous system which has dehumanized us for centuries. We certainly don't want to go back to that. Are there any other quick questions or comments? Yes, sir. Does what I'm saying make any sense at this late hour?
Yeah. I just have one small question.
Yes. I'll take several questions and then briefly respond because we have to...
We also have a question.
Yes, sir. Can we finish him and then come to you? Yes. No, go ahead. Go ahead.
I was just thinking, do you think, like, in the light of this Vanchinathan versus Dr. Swaminathan, do you think this undermines Ambedkar's visions of constitutional morality, especially when upper caste interests are cloaked in judicial moves?
Yeah, I think, see, I think this is, I mean, what you're, if I understand you correctly, you are saying that what did you say is cloaked in judicial robes?
I was saying, like, since we all view this as a judicial insulting itself from critique under this case of contempt or defamation, do you think this undermines Ambedkar's vision of constitutional morality, or like especially when upper castes interests are cloaked in judicial law?
Yes. No, I mean, what I've expressed that in the sense saying I don't think, see, the judicial system and the constitution is a fine system. There's, we can always improve it, but it's a fine system. The constitution provides us direct the power to, the right to move the Supreme Court through appropriate proceedings, every citizen in this country, for the enforcement of our fundamental rights. It's a very good, relatively speaking, a very good system. So the problem is not the system or the judiciary. The problem is that there is an oligarchy that is controlling all segments of our society. There's no representative judiciary. People from a few backgrounds with few socialized in a very similar manner, they should also have representation, but there should be proper representation of the country. So it's a failure of representation, and their judgments reflect their background. And what Ambedkar meant by constitutional morality, I understand, is what the Constitution considers to be right and wrong. Constitution considers to, which we find in the moral, normative parts of the Constitution, fundamental rights, directive principles of state policy. And what he was hinting was that this is opposed by the elite that rule this country. So they are fighting it, whether through judicial robes or otherwise, because they're fighting to maintain the old form of government of oligarchy. Caste is oligarchy. Young people like you say, where is caste? Whenever there is concentration of power, that is an oligarchy. Oligarchy today is caste. The form of it was always a caste, but today that oligarchy is maintained falsely through the idea of merit. There is no merit. It's just a way of favoritism for themselves. It's a system of favoritism, right? So we have to understand it in that sense. Take the discussion of constitutional morality as simply a warning to us that this is an oligarchy. They will run this country. They will not share the morality of the Constitution. And that's what he said. Yes, sir.
So you talked about the presence of theocratic judges after 2015.
Yes.
Can you briefly elaborate on that?
Yes. Theocracy, as you know, is where religion rules. Theocracy. Theocratic is a set of is an idea where you draw the principles of governance, fundamentals from religion. So a theocratic judgment is a judgment where, when you read it, you find that the judgment is drawing its fundamental Grundnorms, its basic norms, from religion and not from the Constitution. The Constitution Grundnorms are in the basic structure, are in Part 3, Part 4 of the Constitution, or the preamble to the Constitution, but they go to dharma. For example, we talked of dharma, dharayati iti dharma and all that, right? Dharma actually doesn't mean, with great respect, just law. It means dharayati iti dharma means anything that upholds anything is dharma. It's inherently not a content that can be filled with any meaning. Hitler has his dharma, Buddha has his dharma, everyone has his dharma. Means whatever upholds Nazism is Buddha's dharma, whatever upholds ahimsa and so on is Buddha's dharma, right? So what I feel is that that we need to ensure that we need to scrutinize and call out judgments whenever the judgments reach out to religion as a basis of their decisions. We need to explain, because see, sense of values, which is at the heart of law and justice, comes ultimately from society, but there is a bridge through which it must come, and that bridge is it must come through a democratic process and be included in the Constitution. and must be read in light, must be complementary to the existing basic structure of the Constitution, cannot conflict with it. That's why, for example, EWS is jarring in the Constitution because it does not, I argued in the Supreme Court against EWS, and I tried to make this argument, it does not gel with the basic structure of the Constitution. And it's a jarring injury to the Constitution, EWS. So there is a path by which you draw on the axiology of society, you draw values from society, and through a democratic process, you cross a bridge from the society into Constitution through Parliament, both houses, amending the Constitution and putting values into the Constitution that are consistent with its basic structure. And it's only from there that judgments must draw their basic norms and values. They have no business to go outside that into society and call from this Veda or that Shastra or that religious book. They have no authority to do that. So that's what they're doing. Okay. If they do that, that's wrong. And some of them are doing that. Anything else? Yes, we have to pass on. Right. Yes. Sorry, we've run out of time. Yeah. Sorry, my time is out. So thank you so much. Sorry about that.